please. Okay, go ahead, sir.
My question is for Matco, and it revolves around distances and consolidation in the industry. There's been a big question about dispensaries, grows, and infused product manufacturers all in the same building. And the question of Denver City Council actually brought about transportation between. If you have an off-site grow for an infused product manufacturer, can you legally move your raw product, which is supposed to be in a product for sale, from your grow to your infused product manufacturing location? The other question is, in regards to that, are all of these considered too close to each other as medical marijuana businesses? And on that same note, if they're not in the same building, 1284 basically says the building in which medical marijuana is to be sold is located within 1,000 feet. Does that preclude infused product manufacturers and grows as far as distances from each other, as far as the state says?
Sure. HB 1284 requires us to engage in rulemaking to deal with the transportation issue. Obviously, there's a mechanism in the bill that allows for a contiguous and or a non-contiguous optional premise license, so you don't have to be co-located at the same place to have a grow. In fact, I don't think you have to even be limited to the same city, county, period. There's no precedent for that in the statute, although I suspect as part of that local side of things that some local governments may take that position. As it relates to the distance restrictions, the bill does provide a foundation in terms of distance restrictions, and I mean I can look specifically to answer your question, but I'm hesitant to do so for one reason. And the primary reason I'm hesitant to answer it directly is the bill allows local government, and this gives them very wide discretion to pass an ordinance or resolution between now and July 1 of next year. And if they pass an ordinance or resolution dealing with these issues, HB 1284 means nothing as it relates to distance. So if I tell you something, it's most likely going to change, and I don't want to be part of giving you that bad information out. What I want to tell you is work with your local government first. If they don't pass an ordinance or resolution by July of next year dealing with these issues, then we'll have a conversation.
Cheryl, do you mind if I put my leg up on the table? My doctors advise me to elevate, and I always follow my doctor's advice. No disrespect intended.
Go ahead, sir.
Can you give us any guidelines for possible structures that involve bringing several centers and grow operations together under one roof that can, or one organization that can meet the requirements of 1284?
I can. How much time do you have? Good question, Nick. It's been a pleasure working with you over the past several months. The reality is that the bill requires each business to be separate and distinct. And if you go back to 1284, we have the 70-30 rule as it relates to the centers. That is, you can sell 30% of your medicine or acquire 30% of your medicine to another dispensary, if you want to look at it that way. That ability does not exist in an edibles manufacturing license. So a grow will have to be attached to a center. Okay? That's the first issue, separate and distinct. The second will be whether or not they can be co-located in a building. Absolutely they can. Again, with a separate and distinct test. If I were to take this room, for example, and I were to build walls, 3 or 4 walls across and make 3 or 4 different sections, the address here could be 123 First Street, Suites A, B, and C. And you could have, for sake of argument, 3 different rows for 3 different centers. You could have 3 different licenses. You could have millions of ways to do it. They just must be separate and distinct, and that's the critical component here.
My question is, anyone can shed light on this, but particularly directed to Mr. Cook. In the applicability section of the statute, the very beginning of this is to, the established is defined by the statute as paying sales tax. But locally approved is that people already in business as a locally approved business for the business of manufacturing, etc., cannabis. That is ambiguous in my judgment. If it is to be interpreted that businesses who have been approved only for the business of being a dispensary or being a marijuana-infused product, being an edibles manufacturer, would be able to apply for a license to continue to do business, unless ordinances are passed and in a year's time. So the only other interpretation possible is that the local approval must not be simply to conduct business, but local approval of the specific activity of being a dispensary or of being an edible seller. Now, it's my understanding that only Denver and Boulder have passed ordinances that regulate the industry locally at all. I suppose there's a few others. I guess Fort Collins has passed something. There are dispensary ordinances other than moratorium in the state, but none of those, to my knowledge, regulates edibles. Therefore, under that interpretation, no edibles manufacturer would be able to continue doing business.
Anyone? I'm sure you're going to probably get the majority of them.
Well, there was a lot in there, and I'm not sure that's a question, but let me just start by saying
It's a surprisingly coherent question, by the way, Chase. Thank you.
Let me just say that I agree with your reading generally of that section, and that technically an edibles manufacturing license and an off-premises grow license are not recognized by anybody until July 1 of next year. That's what this law says. Okay, that's the first step. In terms of an application on file and or a storefront or a locally approved business, there's a number of ways you can do it. In fact, the bill provides you a storefront for paying sales taxes as an example of one of them. But I think I could also argue that if you have a zoning approval or any of those kind of things issued at the local level, that it's truly a local issue. And I agree with you, it's very subjective.
Would then anyone who had a business license, had been doing business as a dispensary or as an edibles baker or seller, would they, unless evidence of fraud in the obtaining of that license were presented, would they not be able to do business as a medical marijuana center or as a medical marijuana-infused products?
As far as the state's concerned, absolutely. But again, I don't have any say-so until July 1 of next year.
Well, no, I'm talking about this year. Would approval, as opposed to established business, would approval be demonstrated simply by the possession of a business license? We have examples. For instance, I know of an edible maker in Denver who was advised by excise and license that she needed a business license and has acquired a business license for her edible bakery. The nature of the license is a wholesale meat distribution license.
Okay, I think we've answered the question. It may not be the answer you were looking for, but that is the best answer that he has.
And the answer really is you need to work with your local authority at that point. From my standpoint, I don't have an issue with it. You have a storefront, you have zoning approval and all that. I'm in your corner, but it's not my call. It's the local government's call. That's true.
And I do have a thought on that because it is a good question. My thought, and I'm advising people, the law 1284 says locally approved business or even just filing the appropriate applications. Therefore, my interpretation, and this is somebody who may have to defend this in court, if you're running a generic business, nearly every locality, whether it's a medical marijuana related business or not, nearly every locality, county or municipality requires you to file something to do that business. You file that thing depending on where you are, a business license, Denver requires an occupancy license, they may require some type of kitchen license, although the state does say it's not food, so whatever the local requires you to do that, and then just